Good afternoon, everyone. We're going to go ahead and get started. Thanks for taking time out of your busy day to join us. I'm Jenna Kirsten, your moderator for today's webinar on GDPR conditional requirements. Let's go over a few things before we dive into our discussion. All attendees will be muted throughout the session, but we do encourage you to ask questions using the Q&A feature, which is located in the WebEx toolbar. I'll monitor those throughout the hour and we'll have some time reserved at the end to answer questions. This session is being recorded and all attendees will receive a link to the recording as well as a copy of the slides in your inbox tomorrow. Just a little bit of background about Kirkpatrick Price. Kirkpatrick Price is a licensed CPA firm providing assurance services to clients worldwide. Our firm has over 13 years of experience in information assurance by performing assessments, audits, and tests that strengthen information security and compliance controls. We offer both regulatory compliance and information security services. We provide consulting services such as policy and procedure drafting, risk assessment, internal audit plan and development, and readiness audits. We also provide guidance and audit services on frameworks such as SOC 1 and SOC 2, SOC for cybersecurity, PCI, HIPAA, HITRUST, FISMA, ISO 27001, and of course GDPR. We also want to encourage you to connect with us by subscribing to our blog, visiting our library of recorded webinars so you can catch up on any series at any time, and following us on LinkedIn, Twitter, and Facebook. Now I'd like to welcome our speaker for today, Mark Heinle. Mark is the Director of Regulatory Compliance at Kirkpatrick Price with over 10 years of experience in private practice, regulatory affairs, and internal regulatory compliance. You may have heard him on our other GDPR webinars. He's our resident expert here, so welcome, Mark.
Thank you, Jenna, and thank you to the rest of you for joining us today. Before we begin, I need to give our standard legal disclaimer. We're happy to have you, and we genuinely look forward to sharing our knowledge on information security and regulatory compliance topics. But we do have to make sure that everyone understands that this presentation is for educational and informational purposes only and does not constitute legal advice, and therefore no attorney-client relationship is established by viewing or participating in this presentation. And should you need legal advice, we recommend that you consult with your own attorney. Now that we've got the disclaimer out of the way, we want to introduce today's topic. It's GDPR conditional requirements. There are actually requirements when it comes to GDPR where you might come out with the decision and still be compliant, but you don't actually have to implement a control. So that's what today's topic is about. Let's give you a little bit of an agenda for our presentation today. We're going to talk about the need for accurate GDPR language when it comes to conditional and absolute requirements. And we're going to give you some examples of absolute requirements. The bulk of GDPR are requirements that apply no matter what. There are no exceptions or conditions that have to be met, but there are a few conditional requirements. Then we're going to talk about some decision-making paradigms for approaching conditional requirements, implications of conditional requirements, and then we're going to look at the 4 real conditional requirements in the law, and we expect to have a few minutes towards the end for questions from the audience. With that agenda in mind, let's get started and talk about the need for accurate GDPR language. So one of the things that we consistently note when we're interacting with clients and interacting at conferences and reviewing other educational material is the tendency for slightly inaccurate or largely inaccurate wording and language when it comes to GDPR. For example, probably the most common example is the distinction between someone using the phrase EU resident or EU citizen versus data subject when they're talking about the kind of person whose data is covered by GDPR. So it matters because the law, I think, covers the personal data of those who aren't just residents or citizens of the EU. And so it's important to be precise and accurate with respect to that language because it's going to impact how organizations build their compliance programs. Another example is the use of the term sensitive data versus personal data. This is a reference to the kind of data that is covered by GDPR. A lot of other data privacy laws and frameworks cover certain types of data that would be considered sensitive, such as healthcare data or financial information or educational records. But when it comes to GDPR, there are levels of data within the law, but those levels are there to help an organization determine whether it's allowed to process and then whether it has appropriate heightened controls. But GDPR doesn't just apply to what might be called sensitive data or confidential data. It applies to any kind of personal data. And then finally, the distinction we're going to make today is the consideration of mandatory versus conditional. When I read educational content or blogs or hear webinars or presentations where practitioners and organizations identify certain parts of GDPR as a requirement that is mandatory rather than conditional, it's not just incorrect, it's potentially costly. So we're going to try to use accurate language, not only for those first two topics as we've done in other presentations in the future and in our engagements, but today in particular, we're going to focus on what requirements are potentially conditional and potentially not applicable to some organizations. All right, now that we've covered the need for accurate GDPR language, let's talk about some examples of absolute requirements. As I said, most of GDPR, the requirements apply. There are no conditions and there are no exceptions. There may be conditions or exceptions within applicability of those requirements. That is, certain requirements may apply in certain cases and not apply in other cases, but they're uniform to any entity that's subject to them. So the first is legal basis for processing. There is no condition or exception for not having a legal basis for processing. There are multiple different options that might serve as a legal basis for processing, such as contract or consent or a legal requirement or a legitimate interest. But every single processing activity under GDPR has to have a legal basis. There's no conditions or exceptions. Similar with transparency. That's why you see privacy policies being strengthened and amended based on GDPR, and other communication, including emails and cookie disclosures on websites. The transparency requirements within GDPR are absolute and apply to every organization. Third, data security safeguards. There are no options for implementing data security safeguards. Now, those security safeguards are what's appropriate in terms of security safeguards depends on the kind of organization, the kind of role it has, and the kind of data it's processing, and the kind of processing activities it's engaged in. But every organization that's subject to GDPR has to have security safeguards. Similarly, organizational and technical controls are a requirement for the protection of personal data, are requirements for every organization. Facilitating data subject rights. Now, this is an area where it gets a little bit tricky, but every organization that's subject to GDPR, whether it's a controller or a processor, has some responsibility in facilitating data subject rights. Now, there are certain rights that are absolute, like the right to object to direct marketing. There are no conditions or exceptions. The request must be granted. But then there are other rights where organizations need to review the nature and basis of the request and see if it meets the conditions required. And then also, even if it meets the conditions required, the right may be denied if there is an exception for the controller. Controller processor standards, such as contracts and oversight, those are requirements for every controller and every processor. And then finally, international transfer mechanisms. Again, any organization that transfers data outside the EU must have an appropriate international transfer mechanism, whether that's an adequacy decision or binding corporate rules or the model contract clauses or derogations for specific situations such as a one-time transfer that's based on consent. Every single organization that transfers data internationally must have a valid transfer mechanism in place. So the goal for today's presentation is not to walk through those requirements. We've talked about them in other presentations. The goal here is to talk about the conditional requirements to give you the conditions and exceptions, and then to help you give you a paradigm for making a decision about those conditional requirements. So moving from least serious to slightly more serious to absolutely serious, I want to offer you a couple of different decision-making paradigms when it comes to the conditional requirements within GDPR. You could simply flip a coin and say heads that we're gonna comply with the requirement, and tails we're going to decline, and then that would be a very quick and clear way of making a decision. And in some cases, people who have been reviewing and trying to implement GDPR might feel like the coin flip paradigm might be as effective as any other in terms of reviewing the law and guidance and talking to practitioners. But there are some other models that are available too if you want to do something besides a coin flip. The second decision-making paradigm that you could use is what I like to call the Facebook model. This is slightly humorous, but also serious. Facebook was one of the organizations that most in data protection, data privacy world thought would be the first organization to receive investigations and potentially sanctions under GDPR. And that was a pretty safe bet, and it looks like that bet is coming true. What you see in front of you is an enforcement notice from the ICO. This is the very first enforcement notice that we know of that's related to GDPR requirements, issued by the ICO from the UK to AIQ, which is a organization, data analytics and aggregation organization that's related to the Facebook and Cambridge Analytica incident. And so they were issued this enforcement notice that talks about legal basis for processing and transparency and fairness. And while the potential fines are relatively modest, I think it's $500,000. This is the first chance to see what will be considered a violation of GDPR and how organizations have tried to comply. So one way to figure out how to deal with some of the requirements of GDPR is just to watch what Facebook does and potentially do the opposite, and just say thanks to Mark Zuckerberg for leading the way. But there's some risk in that, the enforcement action, at least that we see in front of us, doesn't cover any of the 4 conditional requirements that we're going to talk about today, and it may be a long time before we get specific information about what Facebook did or didn't do right. A third decision-making paradigm that is clear but not necessarily the most wise is the Nike model, which is just do it. So when it comes to any conditional requirement under GDPR, dispense with any analysis of whether or not your organization has to, and just comply. And so turn everything in GDPR into an absolute requirement. And that certainly is a clear way to do it, and it's probably more compliant than the coin flip model, and certainly one that you can apply faster and sooner than the Facebook model. But there are some consequences of taking the Nike approach to the conditional requirements within GDPR, and that's really why we're spending our time talking about these conditional requirements today. So in other words, why not just do it when it comes to the conditional requirements? And there's 2 basic reasons. We're going to talk first about resources. All 4 of these requirements are going to include at least one of these resources, if not a combination of all 3. All of them are going to have significant financial implications. A designated representative, one of the conditional requirements we're going to have, is going to incur some potentially significant costs because of the liability that they bear and the expertise that they provide. When you talk about records of processing and data protection impact assessments and data protection officers, there could be significant human resources involved in conducting a data protection impact assessment or using an existing employee to serve as a data protection officer. And then there could be significant technological resources used in records of processing, for example, coming up with a model and analysis to compile those records. There could also be significant technological resources used in the performance of a data protection impact assessment. And even a data protection officer might need certain technological tools to perform their duties. So you could say just do it, but it's going to cost you in terms of money, people, time, and technology. Another reason to potentially not just do it is the potential for regulatory exposure. You may be subject to sanctions if you voluntarily but incorrectly implement a conditional requirement. And specifically that applies from the Article 29 Working Party's guidance on data protection officers, but I think it could also apply to the other 3 conditional requirements. That is, if you appoint a data protection officer, even though you weren't by law required to have one, and that data protection officer either didn't meet the qualifications or doesn't have the required independence or doesn't fulfill their duties, then you could be subject to sanctions even though you didn't have to have a data protection officer. So if you decide to comply with these conditional requirements out of the abundance of caution, just note that you could be subject to sanctions, and it might be difficult, if not impossible, and unfruitful to make a claim that you didn't have to, you were just doing it to be cautious. You may be putting yourself in the position for those requirements to be absolute. So that's why this is a significant conversation. All right, let's talk about the 4, a real actual decision-making paradigm that sort of splits the difference between the 3 I just gave you. One is reading the text of the law. First, that's always the best place to start. Second is looking at the European Data Protection Board guidance. That's the organization that replaced Working Party 29, but adopted and certified their guidance. So there's guidance that's already been put out, and there's going to be continued guidance that's put out. Guidance published by various supervisory authorities. There is a decent amount of information out there from the different member states' supervisory authorities. And then 2 things that have an asterisk: supervisory authority lists and codes of conduct. And I have an asterisk around them because those are not fully completed yet. There are a few proposed lists, for example, for data protection impact assessments, but some of those lists are just in the proposed stage, and the codes of conduct are still in the future. But these are 5 different resources that would help an organization make a sound decision about whether or not to comply with a specific element of GDPR. All right, I've given you at least 4 different options for meeting these, deciding how to handle these requirements. Let's talk about the 4 specific requirements. The first is a records of processing. Second is designated representative. Third is data protection officer. And the 4th is data protection impact assessment. So we'll go through these in order and talk about some of the different conditions. First, records of processing activities is a requirement based on Article 30, and it says that controllers and processors have to document specific content related to their GDPR activities. There's a list of required content for controllers, and then a different list of required content for processors. And that responsibility must be carried out by controllers and processors unless an organization employs less than 250 people, and the processing is occasional, or the processing could not result in a risk to data subjects, or the processing does not involve special categories of data or criminal convictions. So that's the specific requirement within the text. Let's look at some of the different elements of this to help you understand whether or not this might apply to your organization. Here is a handy graphic on the records of processing decision-making from the Isle of Man, where one would go when they're looking for data protection guidance, as one does. But this helpful little chart from the Isle of Man. It's basically, if you have more than 250 employees in your organization, then you don't have to do anything else. No more analysis is needed, and you simply need to begin documenting your records of processing. If you have less than 250 employees, then you move to the decision-making step of whether or not your processing is occasional, and that's the most complicated. If it's more than occasional, then you need those records of processing. If you have less than 250 employees and your processing activities are not more than occasional, then you would evaluate whether or not your processing involves any special categories of data. That's things like healthcare data and racial data and trade union membership and biometric data, among others. And then if you only had occasional processing and it didn't involve any special categories of data, then you would look to see if your processing involved any data that was related to criminal convictions or offenses. And if you could say no to all of those, and the final question would be if you could also say that your processing would not be likely to result in a risk to the rights and freedoms of individuals, then you've met all of the exceptions and you don't have to comply with that requirement. But if you say yes at any of those stages, then you're subject to that requirement. So what happens when you get through this, that decision-making isn't too complicated, and you at least have a graphic, but the challenge mostly revolves around the use of the term occasional. So how do I know if I have less than 250 employees, how do I know whether or not my processing is occasional? Because it's easy to know whether or not your processing involves special categories of data or criminal convictions. It's a little bit more challenging to identify whether or not the processing is likely to result in a risk to data subjects. But the hardest thing to know is whether or not your processing is occasional. So the guidance from the Isle of Man that we just looked at uses the reference of once or twice per year for the term occasional. That's really, really minimal standard that's going to make almost everybody have to document their records of processing activities. Working Party 29 put out guidance that said occasional when it comes to records of processing activities means that it's not carried out regularly and occurs outside the regular course of business. Maybe a little bit more helpful, but doesn't give you a lot of specifics. The Information Commissioner's Office gave a couple of examples to try to help. They said an occasional employee engagement survey, and they actually used the word occasional in trying to help us understand the definition and meaning of the term occasional, which violates all kinds of grammatical rules. But they said that was occasional, and for that employee engagement survey that happens, maybe it happens once or twice per year, then you don't have to comply with the record of processing activities requirement. On the other hand, an organization that's conducting payroll processing, which is going to happen, activities involved in payroll processing may happen daily, if not weekly, biweekly, and certainly monthly. In those cases, that's greater than occasional, and an organization would have to document its processing activities regarding employee payroll processing. So we went with this first, the term occasional first, because that's the first hurdle that most organizations are going to have to address. The special categories of data and the criminal convictions, you either have them or you don't. As long as you know the correct list of special categories, then you just have to identify whether your organization processes them. It's a yes or no, it's a defined term. But occasional and then likely to result in a risk to the rights and freedoms of individuals, those are two very subjective terms. The guidance that we have says that if a processing activity is likely to result in a risk to the rights and freedoms of individuals when it's intrusive or has adverse impact on data subjects. Again, that gives us a little bit of guidance, but not much. And so we go again to the ICO for an example, and it says profiling a database for insurance risk classification results in a risk to individuals because there could be some potential consequence on that individual's involvement with an organization if they're increasing insurance risk. So typically when you think of risk to rights and freedoms of individuals, think of things like identity theft and fraud, but also things that are a little bit more broad than that. The GDPR and guidance around it consistently refers to things like freedom of expression, the ability to use a service, denial of access to a contract because of processing activities. So it's things that are more typical when you think of data protection, and then also things that are less typical and more likely to be involved in sort of a civil rights consideration. So if your processing activities were more than occasional or involved a risk to data subject then you have to comply with that requirement. Now, I did want to point out a couple of potential opportunities where an organization may not think of its special categories of data activity or data relating to criminal convictions and offenses, where it might actually be subject to this requirement and not realize it. One would be processing data about a spouse or a partner. For example, if an application for employment or a credit or other activity or service involved a status of married or single, and then information about the spouse or partner that could indicate information about the person's sexual activities. And sexual activities are one of the special categories of data. So if you've got information about spouse or partner, then you may have enough information to identify something about a data subject's sexual activity. Religious or philosophical organizations, nonprofits that are publishing attendees at events, it could be considered that if you're telling people outside of the organization who's attending a certain religious event or philosophical event, then there could be the logical connection that individual supports or is a part of that religious or philosophical group, and that's special categories of data. And then finally, trade union emails. If there were emails that went out, even if you're able to see all the individuals in the subject or in the to line who received the email addresses, that would reveal potentially involvement or belonging to a trade union. So while it's clear what a special category of data is or data related to criminal convictions, there may be some ways in which your organization is subject to that requirement without fully realizing it. Now, having given you the conditions, without knowing each organization's processing activities, whether or not those processing activities are occasional or involve special categories of data or are likely to result in no risks to the rights and freedoms of individuals, and certainly not the employee number of all of our attendees, I can't give everyone this. The Information Commissioner's Office says most organizations are required to maintain a record of their processing activities. So here we have a supervisory authority giving a strong indication that the number of organizations that are able to adequately and accurately say no to this requirement is in the minority. Now, what does a record of processing activity look like? Well, here's one option for you. You could just use a napkin and draw a couple lines and write the word website on it, and you'd be done, but you wouldn't be compliant. Unfortunately, we have to do a little bit more than this. But fortunately, also there are templates out there. So this is a partial screenshot of a spreadsheet from the Information Commissioner's Office. They have a template that you can use, and this is from that template. They have a template for, I believe, both controllers and processors, since the list of required content is different for each. And you'll see the columns in green are required fields, and then the column of business function, that's not a required field, but it was included in the template because it might be useful to organizations. So there are resources out there if you determine that your organization must comply with the requirement to document records of processing activities. All right, now that we've talked about records of processing activities, let's talk about designated representatives. And speaking with some GDPR experts and in doing some of my own research, this topic seems to be one that doesn't get a lot of attention because this topic is only for organizations that aren't based or have a presence in the EU. So while organizations that are primarily based or partially based in the EU may be experts in GDPR because they're dealing with it every day and it's not just a part of what they do or a new requirement or something for potential business expansion, they don't need to worry about having a designated representative. So there isn't any guidance. For example, the ICO has lots of really good guidance on GDPR requirements, but they have nothing on designated representatives because it doesn't really apply to any of their constituents. So this is a topic that has significant financial implications, but it isn't getting a lot of coverage. So we're going to try to remedy some of that today. The specific legal requirement is that when organizations are not established in the EU, process personal data of data subjects, those organizations must designate a representative in the EU unless none of these three things occur. The processing is occasional. The processing does not include large-scale use of special categories or criminal convictions, and the processing is unlikely to result in a risk to the rights and freedoms of data subjects. So in this case, this is a conjunctive. The sentence is drafted really poorly in the law, but it appears to be a conjunctive so that if you do at least one of these things in terms of processing activities, you have to have a designated representative. You don't have to have all three in place. Just one of them would meaning one of the thresholds would require you to designate a representative. So let's again talk about some of these statements and see if we can help establish some guidance. So there's two primary ways in which an organization could claim it doesn't need to set up a designated representative. In this case, the first one would be the organizations that have a presence in the EU. So if you're established in the EU, this is not a requirement that you have to concern yourself with. Obviously, though, you'll have lots of other parts of GDPR to consider, but you won't have to worry about designated representative. So what does it mean to be established in the union? It says, Recital 22 says the effective and real exercise of activity through stable arrangements. So a couple of different potential options for meeting that sense of establishment or effective and real activity are an employee or multiple employees based in the EU, a contractor potentially who's based in the EU, but certainly an office that's located in the EU. It doesn't necessarily require setting up a subsidiary or affiliate company. It's not necessarily going to require you to change your organization's corporate structure, but I think at least one of those three would potentially meet the requirement for establishment in the EU, with the potential for a contractor being the option that might be the least solid ground for that. And the most solid ground would be having an office with an EU address. But that would be a much more costly perspective, most likely, and significant if you're going to set up an office, or even if you're going to hire employees. And you probably wouldn't do that just to meet this requirement. You may, and that would be okay. But if you're looking for a more cost-effective option, then you would want to see if there is another exception or condition that would allow you to not have to designate a representative. And that would be whether your processing is occasional. It's essentially the same concept of occasional as it is for the records of processing that we just talked about. In this text, it's contrasted with large-scale processing. And as I said, it's got a really confusing sentence structure. So in this case, I would recommend a conservative approach when it comes to whether or not the occasional is connected to the special categories of data or it's its own requirement. Either way, I would say that it would be, if it happens more than once or twice a year, if it happens with some regularity, if there's a schedule to it, if it's a high percentage of your overall processing activities, if it involves a large amount of personal data items, all of those would be considerations for some processing activity to not be considered occasional. So if you got through and you said, well, it's not about whether or not we're in the EU, but our processing isn't occasional, or it involves processing of special categories, or it involves processing of criminal convictions on a large scale. So what does this designated representative do? Let's just assume in this case that we might have to do this. A designated representative is appointed in the EU member state where organizations have processing activity. You only have to appoint them in in one member state, and you can choose that member state. There are organizations who provide designated representative services with representation in one or more states to potentially offer you coverage across the union. But you only have to designate a representative in one member state. That designation has to be in writing, so it can't be some sort of informal arrangement that is only proffered in order to sort of prevent finding noncompliance. It has to be something that would be formally done. And to make that fully realized, notice of who your designated representative is has to be provided to the supervisory authority in that member state. And then it also has to be disclosed to data subjects. The purpose of a designated representative is twofold. The explicit purpose that's stated is to make it easier for supervisory authorities and data subjects to have access to an organization's processing activities. So while that might not be overly challenging for an EU member or data subject to reach out to an organization based in the US, there might be smaller, or in Canada or certain other developed countries, there might be some undeveloped countries that have processing activities where it's harder to reach them. And so having a representative in the EU that speaks the same language as the data subject and is physically located nearby has its advantage. The other is simply to exercise jurisdiction and liability over processing activities. So the designated representative has one real job. They're required to have the records of processing if you meet that requirement. So these two conditional requirements overlap. And then just as a note, when it comes to considering the cost of a designated representative, they are independently liable for controller and processor noncompliance. So if you wonder when you get to the cost and it feels like it's a little bit high, they have liability, and so that liability is most likely going to be built into the cost of engaging them for their services. All right, now we've finished our conversation about designated representative. Let's talk about data protection officer. This is probably the topic that is of most interest to people or most commonly discussed, is do you have to have a data protection officer? The GDPR says that controllers and processors must designate a data protection officer when processing is carried out by a public authority or body, the core activities require regular and systematic monitoring of data subjects on a large scale, or the core activities consist of processing on a large scale. So this is a disjunctive requirement where you only have to meet one of these three requirements in order to have to appoint a data protection officer. So we'll talk through those real quickly and see if any of those conditions, if you don't meet all three of those conditions. So public authorities are not defined in GDPR. Working Party 29 says that they anticipate that being addressed in national law, and that would generally apply to public authorities would generally be national, regional, and local authorities, but it could also apply to entities carrying out what we call public tasks, such as entitlement programs, public transport, utilities, public services, and other similar services that are offered to the public on behalf of a national, regional, or local authority. So if you are either a public authority or you're performing public tasks, then you have to appoint a data protection officer. The second condition is when the core activities require regular and systematic monitoring on a large scale. So what does it mean? There's two parts of that. We're going to look at core activities first, and then the regular and systematic monitoring second. Core activities means the primary business offering or service offering or sale of goods. That does not necessarily include support functions such as paying employees or IT support. So a service provider could, its core activity would be the software, but if it had EU employees, then the payroll processing for those employees wouldn't necessarily be a core activity. So if your core activity involves large, regular, and systematic monitoring, then you have to appoint a data protection officer. So we're focused on what does your business do, what does it exist to do as your core activity. And then second, we're going to look here at regular and systematic monitoring, what that means, determine if you have to have a data protection officer. The most straightforward example is any and all forms of tracking and profiling on the internet, that constitutes regular and systematic monitoring. So if your core activity is tracking and profiling on the internet, then you have to appoint a data protection officer. If you do some tracking and profiling as a sort of ancillary or support service, then you don't necessarily have to appoint a data protection officer. The term regular, based on different guidance, includes ongoing or recurring at particular intervals, recurring or repeated at fixed times, constantly or periodically taking place. And systematic means occurring according to a system, prearranged, organized, methodical, taking place as part of a general plan for data collection, and then finally carried out as part of a strategy. So I think most core business activities are going to, in my experience, by definition, be regular and systematic. So then this question is whether or not they're on a large scale. Unfortunately, GDPR does not define large scale in terms of a number. It doesn't say, a percentage. It doesn't give a certain percentage. So there is no numerical standard yet. If we go to there could be numerical standards offered either by supervisory authorities or by the European Data Protection Board. But right now, we don't have a numerical standard for large scale. The factors would be things like the number of data subjects concerned, either as a specific number or as a proportion of a population, the volume of data and or the range of different data items being processed, the duration or permanence of the data processing activity, and the geographical extent of the processing activity. So the more data subjects you have, or the bigger proportion of your population, the more types of data you have, the longer that processing activity is going on, and the more EU member states that processing occurs in, the more likely you are to have large-scale processing. And just a couple of examples, there are more in the supervisory authority guidance and the WP29 guidance. A hospital processing patient data is considered to be large-scale. On the other hand, an individual practitioner, an individual physician processing patient data is considered not to be large-scale. And then a large retail website monitoring user searches and purchases in order to target specific offerings to those users would be considered large-scale as well. So this is probably one of the more convoluted conditional requirements to look through. As I mentioned before, if you choose not to, I didn't mention this part before, but if you choose not to appoint a data protection officer, you should have evidence that you performed an analysis about your data processing activities and specifically the volume and the types of processing activities to see if your core activities result in regular and systematic monitoring, and that your analysis supports your decision. So you don't want to do that, document it, and then have your analysis resulting in the fact that 80% of your processing involves of your core services involves regular and systematic monitoring. You want to document that. Make sure you can demonstrate that you didn't just forget about it or ignore it. You actually did an analysis, and you have a justifiable reason for not appointing a data protection officer. And then, as I mentioned before, the implications of voluntary appointment of a DPO. If you appoint one and some part of your data protection officer activity doesn't comply with the law, even if you didn't need one, WP29 says when an organization designates a DPO on a voluntary basis, the requirements under Article 37 to 39 will apply to his or her designation, position, and tasks as if the designation had been mandatory. So this is where we have documented consequences for taking the Nike approach, the just do it approach to a conditional requirement. And I think it's possible that that approach will be applied to records of processing activities, designated representatives, and then data protection impact assessments, as we're getting ready to talk about. All right, we're on our last topic, and then we'll give a conclusion, some ways that KP can help, and then open it up to some questions. Before we do that, real quick, I did want to note, if you do need a data protection officer, there are some significant requirements that are spelled out fairly well compared to some other parts of GDPR. The DPO must be qualified. They should have a knowledge of data protection laws, GDPR in specific, and I think they should also have some awareness of data security. They should have independence. They should be able to perform their function. That involves reporting structure, particularly, and your organizational chart. Who do they report to, and are they independent enough to be able to make a decision or give an adverse opinion about processing activities, or are they going to be, is their reporting structure and set up in such a way that they'll be disincentivized from ever speaking up against an organization's activities for concern about being demoted or fired. They must be accessible both within the organization but also to data subjects. They must be included in data processing activities in a timely basis, so you can't appoint a DPO and then exclude them from meetings and reports and incidents so that to prevent them from giving an adverse opinion. They must be involved in activities like the data protection impact assessment. They need to provide advice and guidance there. They should be also involved in things like data subject rights and security standards and data protection by design and by default, and then other required elements of GDPR. And then they also must be bound by confidentiality. They must have the ability to take both employee internal allegations of noncompliance with GDPR and also data subject allegations about noncompliance with GDPR or complaints, and be able to investigate those without necessarily disclosing the complainant. Data protection officers can be an employee. They can be an employee with other existing responsibilities, and they can also be a contractor that you can hire out your DPO responsibilities. Just note, if you use an employee, that you might have a little bit of a challenge making sure they're independent and accessible. Especially the guidance indicates it discourages the use of C-level executives as DPOs, even though that's a common first place for organizations to go to when they think about internal employees. All right, I think I made Jenna jump around enough on data protection officers. I think we're ready to go on to the final of the 4 conditional requirements. That's data protection impact assessments. This is essentially a risk assessment, although its particular focus is about data protection, hence the name. The specific language of the law is where a type of processing, in particular using new technologies and taking into account the nature, scope, context, and purposes of the processing, is likely to result in a high risk to the rights and freedoms of natural persons, the controller shall, prior to the processing, carry out an assessment of the impact of the envisaged processing operations on the protection of personal data. A single assessment may address a set of similar processing operations. So that's the first part of the requirement, and then as if that weren't enough, to give you a sense, there's sort of 2 layers to this conditional requirement. It has to result in a high risk, but then there's more specifics that paragraph 3 gives us. So in particular, the law says systematic and extensive evaluation of people based on automated processing, including profiling, which leads to decisions that have a legal or similar effect. Those are activities that are described in that first bullet point are the kinds that would be particularly likely to result in a high risk to the rights and freedoms of individuals. Processing special categories of data or criminal convictions on a large scale are likely to result in a high risk to rights and freedoms of data subjects. And then third, systematic monitoring of publicly accessible areas on a large scale would also be likely to result in a high risk. So the law sort of gives you 2 levels of this requirement. And one is you should have to figure out whether or not your activity is going to result in a high risk to data subjects. then you have to go through the process of actually performing a data protection impact assessment. So there is a step before data protection impact assessments, and this is a handy visual from WP29. If on the left-hand side, top left, if your processing activity is likely to result in high risk, then before you do it, you need to see if there is an exception. If not, then you don't have to perform a data protection impact assessment. There are steps that you could take aside from just your own internal evaluation. We're going to talk about some of those. One would be seeking the advice of the data protection officer would be part of it, always seeking the advice of a data protection officer. And if they say we need to perform a DPIA, then that's almost always going to need to be the case. If there are certain codes of conduct that indicate that a data protection impact assessment needs to be performed, then that would be a surefire way of being required to perform one. Or if you talk to data subjects whose data you might be processing, and they say, yeah, that seems like that's likely to result in a high risk to the rights and freedoms of myself and others, then you would need to move forward. So, so the first step is it likely to result in a high risk? And then the second is there an exception to not having to perform a DPIA? How would you know if it's going to perform, a processing activity is going to result in a high risk? There are several activities that are specified in the WP29 guidance. Evaluation or scoring, this is that automated decision-making or profiling part of it, especially related to work, performance, economic situation, health, or preferences. So for example, if you're screening customers for anti-money laundering purposes or performing genetic testing to predict health risks for insurance purposes or creating marketing profiles for website use, those would all be activities that would likely result in a high risk to data subjects. Examples of automated decision-making with a legal or similar effect would be automated employment screening that may lead to discrimination. So if you had some algorithm that took on certain elements of a candidate's resume and their application, and the algorithm automatically made a determination not to proceed, that could result in discrimination, and therefore that would require a data protection impact assessment first. Systematic monitoring of publicly accessible areas, things like video or geolocation monitoring in public spaces. So if you had a security camera in a public space on your building, then or you're thinking about putting one on your building, then you would need to perform a DPIA first. And then sensitive data, obvious examples are involved like healthcare records, hospitals storing healthcare records would be one of the most obvious examples, but also payment processing information. So if you've got information related to like bank accounts or credit or debit cards, those would potentially, processing involving those pieces of information would be subject to a DPIA first. And then large-scale processing. So, for example, a fast food chain tracking real-time location of its customers, or an insurance company processing customer data based on the scale of those processing activities rather than necessarily the sensitivity of the activity or the data. Those would require a data protection impact assessment. If you're taking data sets and either matching them or combining them from different processing activities, so fraud prevention, where you're taking maybe some customer activity that you receive as a financial institution or a retail store, and then combining it with activity on a website or other activity, and you're combining the data sets to figure out if a customer is actually the one trying to access a system or use a method of payment, that would require data protection impact assessment. Processing activities involving vulnerable data subjects. So anything really that involves imbalance of power. So processing activities related to children or employees or the elderly or those who have certain mental or physical disabilities. The processing activity outside of those, the data subjects might not necessarily require a DPIA, but because of the data subjects involved and the concern about imbalance of power, it might require a DPIA. And then finally, new technologies, for example, artificial intelligence or the use of certain of RFID in certain applications would require a data protection impact assessment. So that's not an exhaustive list, but there are actually lists that, while not exhaustive, give you a lot more guidance, with specific guidance on whether or not a data protection impact assessment needs to be performed. So some of the lists from supervisory authorities have been proposed, and some are just suggestions. So the first four are from the German supervisory authority list, and it's actually compiled from across the country from different lists. Large-scale processing of employment data in Germany must have a DPIA before processing. The use of video and audio analysis tools. So if you used voice analytics software or video analysis in your processing, you need to perform a DPIA before that. And the purpose of a DPIA is to ensure that you have controls in place to address the high risk. And if you have controls in place, then you can proceed. If you don't have controls in place, there's some steps you can take, but you may be prevented from proceeding if the risk is great, but the controls are not in place. Fitness wearables. If you're going to be processing around data around that's related to fitness wearables in Germany, then you need to be performing a DPIA. And then also if you're engaging a non-EU vendor. So for all of those located in America or North America or South America or Asia, if German companies that are engaging in our services would need to perform a DPIA before they actually engage with us. Some suggestions, but not a formal list, from the ICO from the UK: customer loyalty programs, internet-connected toys, that goes to the vulnerable population category, credit checks, and smart cars. Applications related to smart cars are all processing activities that would be strongly suggested to perform a DPIA. So one of the challenges with data protection impact assessments is that the lists from different countries on what is required to perform a DPIA, and there are also those are called black lists. There are also something called white lists, where it's activities that don't require DPIA. It's all over the place. So knowing where your processing activities occur is really important to know whether or not you're required, or you've been given sort of get out of jail free card with DPIAs based on a white list. One final note on DPIAs, and then we'll move on because we're running out of time, is that if there's a legal requirement to engage in a processing activity, then and there's a sort of data protection impact assessment as a part of that legal obligation, then you may be also exempted from performing the DPIA requirement. All right, let's move to wrap up and see if we just have a few minutes for questions. At this point, you may be panicking and saying, there's a lot of information, and what do I do now? I've got 4 requirements and different models and different decisions to make. What do we do? Hopefully this will reduce some of your panic. First, perform a quantitative EU data processing analysis. I think this is necessary for all of the requirements within GDPR, not just the conditional ones, but has particular impact on the conditional requirements. Ask the questions: how much data is being processed, both in terms of numbers and data elements. How long is the process activity going on? How frequently does it occur? What kinds of data elements, and where does the processing activity occur? And that will give you, that should be hard and fast numbers. And then do a qualitative data processing analysis. This is not about numbers. This is about risk. So as I mentioned, actual risks like fraud, discrimination, and denial of a service, and things like apparent risk, influencing geopolitical activity. If you're going to be involved in influencing geopolitical activity through your processing, then you're probably going to have an issue regardless of what kind of controls that you have in place. But there are other apparent risks that are less severe that may indicate that you meet some of these conditions and therefore have to do things like appoint a data protection officer and conduct a data protection impact analysis. And then finally, in some senses, just to help this not seem too overwhelming, you really have to make 4 decisions. I gave you 4 conditional elements, so you're really just making 4 decisions about whether or not to comply. All right, so that is our presentation for today. For Patrick Price, we're here to help. If it's best, beyond just giving you empowerment through education and advice, we perform GDPR gap assessments. We do GDPR compliance audits. We also help draft policies and procedures. We perform consulting, and then we also, for controllers, perform processor oversight. So if you need a partner in your GDPR compliance activities, we're here to help. All right, I think that's it. Jenna, do we have time for questions, or did I take it all up?
We'll go over a few minutes, but I do think these are some really good questions asked today. Just quickly, we have, if your company does meet these requirements, must you have a designated representative in the EU, or can you just have a DPO, or are they completely separate requirements?
It's a great question and a very common one. In fact, I learned recently that some foreign language translations of GDPR use the same terms, same language sometimes when it comes to DPO and designated representative, so it's confusing. There are 2 separate requirements with 2 separate functions. A designated representative must be based in the EU and has a very specific function. That's to be an interface between supervisory authorities and data subjects and an organization. You give them your records of processing, and if you didn't have that, you would give them something like your privacy policy and some other information. And they're in the EU to be an accessible point of contact. They may perform other services, but their job is not to tell you about whether or not, their job is not to do internal monitoring and auditing. Their job is not to design security safeguards. Their job is not to give you advice around international transfers. The data protection officer is the internal or contracted GDPR resource. The designated representative is sort of a geolocation-specific representative. Now, I know some of them perform activities like breach reporting, which is an additional activity they're not required to. But DPO is going to be involved, should be involved at a much more thorough level, and they can be based anywhere in the world. The designated rep has a very specific function that they have to do, and they need to be based in the EU. Hope that answered that question.
Yeah, that was great. Another one was, if an organization has a data protection officer in the EU as part of a subsidiary, is the company able to transmit information between the EU and the US?
It is. There's an opportunity for that organization to use binding corporate rules. They just need a valid transfer mechanism. And for that, they could use something called binding corporate rules. It's a similar concept to like articles of incorporation and other formal corporate documentation. It has to be submitted to a supervisory authority and approved, and it commits an organization to certain data protections. But in that case, it's not the fact that it's within an organization doesn't eliminate the organization's requirement to comply with the safeguards for international transfers.
Great. And then our final question is in regards to kind of the audio-visual camera rules. Someone just wanted clarity on if that only applies to an organization physically located in the EU.
It's a good question. I think that's the most reasonable interpretation of that, is that if you're monitoring EU data subjects in the EU, that your cameras are focused in EU places. So if you had an office there and you're monitoring employees, or you had an office and you're monitoring customers, or you had a location, you're monitoring a public space that was outside of an office, but it wouldn't I don't believe that would apply to organizations with cameras that are focused on non-EU locations.
Great. If you submitted a question and we haven't gotten to it today, you will see an email from myself and Mark, and we'll get those questions answered for you. And as a reminder, you will also receive a copy of the slides and a recording of this presentation in your inbox tomorrow. So thanks, Mark, for that great presentation. That was very, very educational, and everyone have a great rest of your day.